what the accused persons are simply doing is to place evidence that is required in terms of the rules of this court, as well as the constitutional rules, when the court is dealing with issues of referendum. So, an import of Section 66 inform us that that section is applicable where there is an ordinary trial. That section will not be applicable in this circumstance. And my Lord, I noticed that something has just caught my ears, but I may proceed. So, my Lord, the evidence that we seek to establish from the witnesses that we are calling is really about two issues. Number one, which is whether or not there was interference with the past judicial decision made. Is whether or not there was external interference with the decision that had been made by members of the National Prosecuting Authority to grant a consent, and after the external influence, that consent was then revoked. So the issue really there is about the question of independence of the NPA being interfered, therefore violating the rights of the accused persons. The second issue, my Lord, that we seek to establish is whether or not there is selective prosecution. In this case, and whether or not the Zimbabwe anti-corruption is exercising its duties that it is supposed to exercise in terms of Section 256 of the Constitution. Yes. So, madam, I just wish to push it on the record that the procedure. No, I'm making submissions. Apart from my language. Madam, the submissions that we are making, in as far as the calling of these witnesses are concerned, is that it is not in the ordinary where one then usually, prior to the trial commencing, either to be in this case, a statement. And usually the norm is that such a witness must be supporting your case. But we are not even sure as to whether or not these witnesses you are calling are going to really support the evidence of the accused person. And we submit that it is critical for us to call in order for this case, or in order for the accused person to establish certain facts and elicit certain evidence from those cases. The person reading a lot is not whether they can really support the evidence of the accused person which is 229 is only section 208 of criminal procedure in order to secure the attendance of those witnesses. I occasion to enjoy the judgment in state versus civil and your reasoning in that case was quite clear that in criminal proceedings, witnesses are available and the courts can invoke the law in order to secure such witnesses. I move you, my lord, to say that this is appropriate under these circumstances, but there are two spaces involved the law in order to secure the attendance.
I know the statement is false, but I didn't want to appreciate the point that are you saying that the procedure that applies to the calling of witnesses does not apply to the situation?
Yes, I believe so.
You are saying the court, you are claiming one investigation.
It's not really an investigation, it is we are calling these witnesses in order to establish factual issues.
Those factual issues are known. You only seek to establish facts that you already know for the benefit of the court, which is so. In other words, you can only raise you can only base your application on some facts that are already known.
Yes,
not facts that you are yet to establish. In a system like ours, which is adversarial, you want to establish. You know how you want to establish through facts.
Yes.
The facts that you want to rely on to establish your case must be known to you.
Yes,
yes. I don't think even because you are representing the accused persons, you can go on that fishing. All I'm saying is that it is tried. You don't require any authority. That you really need to know what you want to do. You go to something that you already know. You cannot really be calling new procedures to find out from them what they know, whether they may be beneficial to your case. What procedures? Tell me any procedure, any group in this criminal procedure that is a procedure that any section that allows it.
My answer to you is that the facts that the accused person wants to establish are known to them, and which is why they have taken to the witness stand to establish those facts. However, my lord, there is rather an opposition from the state that is contesting those facts. And in order to establish those facts, it is critical, my lord, for the witnesses that we want to call to be called, so that the accused person can have an opportunity to elucidate certain evidence from those witnesses. Because
wait a minute. We have facts that should be included.
Yes. Yes.
And the evidence that
Yes.
So the evidence is for you to be satisfied that such a fact can happen. You cannot speak of a fact, assert something as a fact, when you have not established yourself. I'm just speaking from a common sense point of view. You cannot assert facts which you have not ascertained yourself. You know, if you are going, this court cannot be part of an investigation.
My lord, it is not really an investigation. What we want to seek are factual issues from those witnesses.
Yes, but do you know whether they have those factual issues?
I know for a fact that they have those
How do
factual
you know?
issues. Because, my lord, the allegations being made, or the allegations or the testimony of the accused persons, to say that when this decision was taken, so and so was present,
Yes.
and they participated in that decision.
Yes.
It is therefore critical for the accused persons, where they know that the person is compellable, to put them on the witness stand and then elucidate whether or not.
How do you want to propose to do that? Remember, you are going to be leading evidence in chief.
Yes, my lord,
Yes.
it's an issue of putting the questions to the witness.
No, evidence in chief is evidence. You are just adducing evidence that you already know. You are leading a witness. You don't call a witness in order to cross-examine. I mean, that is basic. You don't, but anyway, let us hear from. Is there anything else that you want to say?
Nothing further, my lord.
Yes, state.
Perhaps before I sit down, my colleagues, just pardon me, my lord. My colleague seems to be. My lord, I'm being advised that some of the witnesses have actually been called by the state. My lord, I believe that in view of that fact, that perhaps the state is making a concession that we can proceed to place the witnesses.
Listen, I'm not resisting. I'm just seeking clarification. Because this is, I have not, throughout my experience, I have not come across a situation where a party calls somebody as a witness when they do not know what they are going to say. In other words, you must have at the very least spoken to that person, and you must be satisfied that they are going to give evidence which furthers your client's case. But it's entirely up to you. These are your clients. If you think that is the best way of advancing their case, you will. But I was just interacting with you in terms of the procedure as we know it. Yes. But at the end of the day, if those are the instructions that we have, I can't really stop you from doing that. But going forward, let us try to abide by the procedure, the Criminal Procedure and Evidence Act. We can't dispense with, what the Criminal Procedure and Evidence Act says. Yes, we can't. We can't be that convenient. It's not up to us. This is a court of law, you see. So even if we agree, we cannot agree to do the wrong thing. But anyway, let's hear from the state.
My lord, before adjournment, what had been agreed upon was that the defense team was going to provide a summary of what each witness was going to say in respect of the three witnesses that they identified. The need for the summary of the evidence of the witnesses is not for their convenience, but it is for even the other party not to be ambushed. It has to prepare as well. So I think the understanding of my colleagues for the need of having evidence from witnesses to be summarized, I think it is misplaced. It is not for their convenience. It is for the convenience of everyone. Even the court has to be aware of what each witness who is going to be called is going to say. So really, I don't know where this court enjoys an inherent jurisdiction, even if Section 66, subsection 6 does not apply. But this court had made in order that summary be done. That order was supposed to be, the defense team was supposed to abide by that order. Now they are coming back and say they can't provide a summary of what each witness is going to say, then the state is at a loss. We are not mere spectators in these proceedings. We also need to prepare. So the procedure that are adopting, it's ahead of.
Madam, if I may come in on behalf of the defense to perhaps make our case. First, we wish to respectively submit.
You are...
I'm flying on. Thank you for that. We first want to respectively submit that we would want our application for referral to be governed strictly in terms of the law of the country. So we are with the court when it says that we must follow the provisions of the law. We are not submitting to this court that there be some departure from established rules. When we came back from lunch, our submission was that in terms of Section 66 of the Criminal Procedure and Evidence Act, that would not be the applicable provision of the law. Because that Section 66, we have already complied with it in relation to the issue of a trial. I mean, our witnesses are well known, and we've summarized what each witness would say should the trial kick off. But following the request which we are making, which is the proceedings we are making, which is a request for referral, we were unable to find in the Criminal Procedure and Evidence Act provisions that would govern the calling of witnesses that are specifically focusing on referral. And we respectively submit that we must proceed by a reading of the Criminal Procedure and Evidence Act alongside other provisions of the law. And that's why we relied on Section 229, which requires, in fact, gives us a right, if we were in a trial, to compel witnesses to attend. So we're proceeding on the basis of compelling witnesses. So if you compel a witness, like if we're using Section 229 of the Criminal Procedure and Evidence Act, we would be entitled to, for the lack of a better word, request that a witness be brought, not necessarily to lead evidence in the normal way of examination in chief, but to put the witnesses, to compel the witnesses so that they answer certain questions, which answers would assist the case we are making. That's the process we are proceeding under, my lord. I thought we should explain that. And my learned friends perhaps are entitled to raise the issue, but that is why we had said they could bring in, and the impression they gave us was that they were not going to be objecting, because they had already assisted us, one of the witnesses already around for that purpose. So, my lord, we are proceeding under the law that would require, that would allow us to compel witnesses. So in this case, the court must be guided not just by the Criminal Procedure and Evidence Act, it must also be guided by the rules of court relating to the establishment of facts that are in Rule 108, Sub-Rule 4, and then in the rules of the Constitutional Court as well. That would be the rule, I think it's 24.4, which require you to establish facts. Then we have also had, it's Rule 20, my learned friend, it's 24, the rule for it, it's 24.22 of the Constitutional Court Rules 2016.
Wait, I need to get there. So,
it's Rule 24, Sub-Rule 4. Then in the High Court...
Wait. So which law are you utilizing?
If we go by first, the Constitutional Court rule says that where there are factual issues, the court sees this matter shall hear the parties determine factual issues, provided that, of course, where there are disputes of fact, the parties shall prepare a statement. Now, when they say that to hear evidence from the parties, our submission is that in hearing that evidence, the parties can utilize the provisions generally of the law relating to compellability of witnesses. And here, my Lord, I was going to say, if the court permits, that this court sitting in this kind of sui generis proceedings may also be guided by the Civil Evidence Act, because it's more or less the referral application cannot strictly be said to be a criminal proceedings, only that it's a referral application that is arising in criminal proceedings. But it is itself a civil proceeding, if we may try and put it that way. Then when we look at Civil Evidence Act, I'll refer the court to section 56, I think.
You're assuming that I already have those pages open.
I'm sorry, my Lord, that I stood on a point to respond to the law, because we were very worried that the impression might come that we are trying to beg the court to bend the rules. We are not doing that. We are really strictly...
No, I'm just surprised that we are having to go that far. In the first place, where there are no, where there's, as you say, there's no specific procedure, the court gives directions.
Yes.
And I gave the direction that we need, you need to set out the facts that you need, the evidence in summary. So I thought that is the way to proceed, and the understanding was that when we come back from the lunch break, the accused persons would be, giving us a brief summary of what evidence they're expecting from those witnesses. So there's no need to go even this far, because that is, those are the directions that I gave. And those directions are based on our understanding of, procedure. You know as much as I do, that when the court has to, if something has to be established, either because the court has detoured into some, inquiry within a trial, or call it a trial within a trial, the procedure to be followed is as close as possible to the trial itself. Just that the court has detoured from the main trial, and it has detoured into a trial within a trial, or an inquiry. But the procedure is that the person who assets must prove, and must be aware of how they are going to prove that fact. The court should not be part of that investigation. I think that is trite. All I'm saying is that don't involve this court in investigation. These are people that can be approached, and you can interview them. You can establish on your own whether they can give the facts that you want to adduce. There's no need for the court to be part of that process. That is what I'm resisting. That's all. I've not really... the issue of compellability does not arise because, as the prosecutors, right, the state counsel said, it only comes in if the witnesses are refusing to cooperate. Then the court uses the force of law to compel them to come. We are not even that stage. I'm actually advised that one of the witnesses here, why would you need a subpoena to call somebody who is already here? All I'm saying, Mr. Mpofu, is please let us not preside over a mistrial. Let us not invent procedures. In a criminal trial, we are diverting now from the main trial. What we have done is we've packed the main trial, haven't we? And we are on some procedure to establish certain facts which are necessary for us to go forward. We follow the procedure as much as... That is why you studied, Mr. Mkia. Because the person who averts something must start and establish those facts. Why do you want now the court to be part of your investigation? Since when has that have happened in the criminal trial? So why don't you do the correct thing, Mr. Mkia? Just talk to your witnesses. They are your witnesses. They are not the witness of the court. Talk to them. Find out whether they are willing to come, what they have to say. Then you tell us in brief.
So in that I'm indebted, my Lord, for that. In fact, it was not so much a misunderstanding. The point that we were taking, when Mr. Mgia stood, he had raised two questions that he put. We had actually thought that would be sufficient in the summary. But
you mean what question? I'm really... You can establish anything that you want to establish as long as it's relevant to the issue of referral. But it's the question of how you're going about it. I'm saying I have never, throughout my experience, had a situation where the court is part of a party's investigations. And I am unaware of, and if there's any section that I've overlooked in the Criminal Procedure and Evidence Act which allows that, then you need to say that to me.
My Lord, once again, we're indebted to that. We are in a position to be able to then set out the summary.
Yes, you may, if you are unable to do so now, you probably do that and then and perhaps make the appropriate application if what you require is time to achieve that.
Thank you, my Lord. In fact, in the circumstances, I will ask, we will make the application now. We would want to respectively apply for a postponement of the matter. To enable the defense to comply with the direction of the court relating to providing a summary of what each of the witnesses that we expect to call would say. These are the witnesses we would not have been able to get their summary before. For two reasons, my Lord. The first being that we were acting under the impression that these are witnesses that would simply compel to give certain information. That was before the direction, so we had not prepared them as our witnesses.
You thought you were able to compel them under section?
We are going to use the general principle, section 229 of the Criminal Procedure and Evidence Act and section 56 of the Civil Evidence Act. In short, my Lord, we had taken the approach as the defense that it was all under the concept of compellable witnesses. So we had then not prepared that summary.
Yes.
And our second reason, my Lord, is that we really were operating under a very unclear framework of how we would proceed. We had taken the attitude that in terms of the rules of the High Court, Rule 108, Sub-Rule 4, and Rule of the Constitutional Court, Rule 24, Sub-Rule 4, that we could proceed in the manner that we had proceeded.
Wait, you're taking the view that you could proceed.
We could proceed that we didn't need to interview those witnesses.
So you are saying you can't say which fact you are calling them to establish?
We have, my Lord, if I may answer that, my little friend was, with respect, clear on that. We know what they ought to come and establish. They have to come and confirm the version of events that has been given by the accused persons. We believe that the state would not call these witnesses to disagree. They might then make our evidence inadequate if it is not confirmed by the evidence of those witnesses.
So the procedure that you were going to adopt was to secure their attendance and then How then do you adduce the evidence? Cross-examine them?
The court might, with respect to use that language, but our approach was that they'll just come in and they have to answer questions as compellable witness.
Right, okay, you are saying any person is compellable even if you don't have to lay a basis for compellability. Any person can be called in any case and they are compellable.
My Lord, this is the issue that we said we had overlooked when we were looking at the rules.
Yes.
But we now accept the direction of the court that...
Oh, okay, you accept that direction that you ought to know that a person is your witness, or is,
Indeed,
and then
we
you call
accept
that
that.
person.
Yeah,
So all you are doing is explaining why you had not adopted that federal.
Indeed, my Lord. I'm explaining why we're seeking this condonation to be then excused, so if we get the postponement, we'll be able to rectify our situation.
Very well, thank you. Is the state opposed to the application? Maybe before we hear further submission.
No, it's not opposed to the application, but it is, the state also wishes to highlight that the defense does not ask for assistance from the state timelessly. Today, witnesses could have been availed if they had asked for witnesses to be availed, because they knew from the beginning that they need to establish a functional basis for their applications. But there was no request for any witnesses to be availed. So I think with that kind of approach to things, it becomes very difficult for the matter to be finalized timelessly. I think it is time for the defense team to liaise with the state if they need for any help, not to wait until the court convenes and then they make an application that we wish the state to assist. The state is, these are the 17 constitutional issues that are being raised. They are being taken seriously by the state, and the state will help as much as possible in order to avail the witnesses that they wish to be available. So there's no need for them to wait for the court to convene to make an application to compel the state. So if they provided as agreed the summary of the state case, one of the witnesses had been availed, the other one...
Who is the witness who is available?
The IO, Chapani.
He's sitting outside?
Yes. And the other two try to phone them. We are making efforts to avail them as soon as possible. This is the spirit in which, if it is adopted by my lady colleagues, we can tend to make some progress. But I don't know what they see in time being tracked, or what benefit they see out of that.
Yes. But also the application for postponement is not opposed, so you don't need to belabor the point. The matter will be postponed anyway by consent. But I need to reiterate that I urge the bar to, liaise and deal with housekeeping issues. The court convenes to deal with real issues that need to be disposed of in court. But issues like this, whether the attendance of witnesses and so on, are best resolved, through liaison. Because as you can see, we are approaching the end of the term. We're just left with 1 month to go. So let us make use of the little time that remains. We have other matters to deal with, so let us, put the time that is at our disposal to good use. The accused persons are in custody, and it's important that we make progress.
Yes, my Lord, I think I needed to record our appreciation of the attitude, the approach that is taken by our learned friends. We need to appreciate that, but we have one last and small indulgence in the sense that when we had said 3 witnesses, actually we need 4 witnesses. And I think that just to make clear to our learned friends that when we discuss as which witnesses, they would not say we are starting outside, so that the court must know that we require a 4th witness.
I think that will be apparent in your summary.
Yes.
In the summary that you are going to prepare to give an indication of the evidence. Then of course you can liaise with the state if you need any assistance to secure the... I'm sure you don't even have to involve the court in subpoenaing the evidence. It's the procedure is already there in the act. Yes. When can we continue? Registrar, when is our next free slot? 11 November. What day is that?
It's a Monday.
It's okay. Evening is okay. The 11th is agreed, my lord.
Stand up, accused persons. This trial is postponed for continuation on the 11th of November, 2024 at 10:00 hours. Since the proceedings are taking place in your presence, I'm sure you are already aware of the reason for the postponement. Am I correct? Very well. I need not explain that if you are not sure about anything, you need to seek clarification from the legal practitioners who are representing you. Very well. So come back on the 11th of November at 10:00 hours. Any other business, Registrar?
No further business.
The court will rise.
But if the company is without subpoena immediately from the 11th or whichever, the weekend.